which I haven't read, but I'm sure it's a really interesting book. So we'll go ahead. At the end, I hope we'll have 15 or 20 minutes maybe for questions. And we do need to be out of here by 5 minutes to 9, so blink the lights. All right? So go ahead.
Kathy, is this for me to do something with?
Well, I couldn't get it to work, so as long as your voice is good, we're going to go ahead.
First of all, I'm delighted to be here. I see a number of old friends in the audience, and I'm always gratified that people who have heard me spout off before want to hear me do it again. Welcome. It's also lovely to be speaking to a group with a name that I really like and respect. Neighbors for Peace. That's great. So it's a pleasure to be here. I want to start by talking about risk to democracy before I get into the court, and setting up what the purpose of the book is. There are extra purposes. There's like that purpose, to get you to vote. There's a purpose in helping you to understand the significance of what the court is doing, and therefore the significance of the nominations that will be coming up, certainly the nomination to replace the late Justice Scalia. But what spurred me to get into this originally was my concern about the future of democracy in America. Studies of why democracies fail took off in the 20th century, when we've had a lot of democracies born and a lot of democracies die. And so there have been many, many studies of that in the 20th century. What the political scientists are telling us is a result of studies done in lots and lots of ways. And I'm looking at you, Kathy, and realize this is a different speech than what you heard. Julie. Julie. I just had my 75th birthday. I'm not responsible for Trudy, this is a different speech than the one you heard, so I hope that's okay.
That's fine.
All right. But what the political scientists tell us is that democracies fail and are replaced by autocrats, military rules, self-perpetuating aristocracies, or revolutionary governments when the disparities of wealth and power become too great, when due process protections are lost, when paramilitary organizations proliferate, and when the structures that hold the people together weaken. And I'm going to elaborate all of that before I can get into the actual work of the book. What does the Roberts Court have to do with all that? In each of these areas, the court takes the wealth and power from the many and shifts it to the few. I have to hold this up because somehow the light is not working. And in doing that, what the court is doing triggers the vicious cycle that political scientists describe and fear. One way they describe it is that increasing the disparities increases the stakes of politics. It just simply becomes more important for people to keep what they've got, or important because they don't have anything. Therefore, it becomes necessary for people to take over the government and exclude others at all costs. So that's one way of describing a major reason why democracies get taken down. Of course, they can be overrun by military force. That's an outside way. I'm really talking about what happens to them internally. A second way the political scientists describe it is the dictator's game. I don't know if any of you have read any of the work of Bruce Bueno de Mesquita. It's fascinating, and his book, The Dictator's Handbook, is a relatively brief description of this. By brief, I mean a couple hundred pages of this, and it's quite stunning reading. But he and his colleagues describe it kind of as reflected in the very familiar story of Robin Hood and the Sheriff of Nottingham, which comes down to us from a medieval fairy tale and numerous retellings in print and on film. Bruce Bueno de Mesquita and his colleagues have explained the role of the Sheriff of Nottingham type figures in the contemporary world. The fewer the people with real power, the more the people who run the government have to focus on those folks with real power. And therefore they have to shovel favors in their direction. Given how wealthy they already are, those wealthy, powerful people don't appreciate anything but very large rewards. But whatever government does for the people, the less there seems to be for these powerful patrons. So the rulers become and employ modern-day sheriffs of Nottingham to take from the poor so that the rulers can give to the rich. It's what Bueno de Mesquita's group calls the dictator's game. By starving the people, dictators have more powerful supporters, have more to give to powerful supporters, and the more powerful they are, the more they want to continue their support. Bueno de Mesquita and his colleagues tested that hypothesis against many different kinds of benefits that governments distribute to their nations. And it's uncanny how well their description of the dictator's game describes everything from public investment to tax breaks. Why are we struggling in the United States about whether we can build infrastructure or not? What? Infrastructure costs money. Who would have to be taxed? You and I don't have enough money to tax to build the infrastructure this country needs. Who has to be taxed? Well, if those folks have to be fed and tended, you can't build the infrastructure. Never mind that economists can say in the long run you'll do better if you have the infrastructure. That was an understanding that Americans had 2 centuries ago. Apparently, we lack it now. They want, their goodies straight out, not as an investment for 10 years later. So, the court has been contributing to this by shifting wealth toward companies and the wealthy, and away from consumers, investors, and workers. I'm going to kind of summarize some of the areas and get back and talk about it at more length if there's time. I assure you there's a lot more to say about any and all of these cases. But let me summarize it this way. The Roberts Court, the last 10 years has been weakening the antitrust laws, which imposed market constraints on company practices. You know that conservatives in this country are always talking about let the market do it. But the antitrust laws were designed as regulations, of course, so that the companies had to let the market control their behavior instead of their behaving as monopolies. So the statement, we don't want regulation, and we want the market, those right from the start are in conflict. But the court has attacked, undercut antitrust rules to the point that it's almost impossible now to prove an antitrust case. Big ones took a decade, well, lots of lawsuits took a decade. How many suits are in your office, Mark, that are a decade old? My first suit that I worked on as a fledgling lawyer with a firm in Manhattan, that suit was 10 years old when I first touched it. I can remember when that accident, this chemical accident that happened in Brooklyn, and I was either in my last year of high school or my first year of college. And then I came back from the Peace Corps about a decade later, and they put that case on my desk to help Hartford on that litigation. So 10-year-old cases are common, but even at 10, it's now virtually impossible to win an antitrust action. You literally have to spy on the people and hear the words spoken. There's virtually no way left to do it. The court has weakened liability for injury. Those of us in law call injury litigation torts. A tort is a non-contractual obligation. You don't have the opportunity to see that pedestrian and say, hey, can I hit you for $1 million? It's not the way it happens, of course, folks. But if you hit that individual, you are responsible. When the Exxon Valdez goes aground in Alaska and does a great deal of damage, or what was it, British Petroleum, BP in the Gulf of Mexico, spewed all of that oil. They have a legal responsibility. States have been the principal enforcers of that legal responsibility since this country was formed. The Roberts Court, some people still think this is a federalist court, that the court loves the states and wants to devolve federal power onto the state. But that's only because most people don't read the preemption decisions. Most people probably don't know what those words mean. But to us in law, it means that the court is saying that there is a federal statute which in its actual language doesn't say anything about this problem, but somehow that statute wipes state power off the board. The state can't touch that field. And this court has repeatedly been blocking state law on the ground that it is preempted by some federal statute. The court has also been restricting punitive damages, another thing which has been traditional for centuries under the common law and under state law. By the common law, that goes back to England. But basically, we think of it as judge-made law. But law that governs a great deal of our commercial transactions. And there's another set of cases where it's blocked liability for aiding and abetting fraud. So if Mark or I advised a stockbroker on how they could deceive their clients, don't worry about it. We're in the clear because we didn't issue the fraudulent statement. We may have been involved in the plan, but we didn't make the statement. The court wants to protect us. It wants to protect accountants. It wants to protect other companies that got themselves involved in sham transactions so that somebody's bottom line would look better. But no, they're not responsible. They weren't the poor fall guy who made the false statement. That's not fraud, according to this court. It's been remaking the law of procedure. When I talked before about it being impossible to prove an antitrust case, that's partly because the court has remade the law of procedure. We start a legal action by issuing a complaint. You know, when you walk into somebody on the street and you say, how are you doing? And they say back to you, can't complain. My law students say that to me, can't complain. And I say, what are you doing in law school? The first thing you do in a lawsuit is you issue a complaint. And the court says, but you can't file a complaint on the ground that you have observed actions or behavior that can't really be explained any other way than as a concerted action between the companies to monopolize in that industry or field. So it's done that to antitrust law by manipulating the procedure. Another thing it's not a hot button item, and we all look for the latest abortion decision or some case of that, or the CUC case. I don't even have to tell you what I mean by CUC. You all probably know. Or the case where the court withdrew the requirement of pre-clearance of changes in voting requirements in the southern states. Those are big hot button cases, and everybody hears about them, and we all understand it. But then there are these procedure cases, and they make things impossible. The court has done that in a number of fields. The court has also used a procedural tool, that is arbitration, to make it virtually impossible for you and me to make any complaint against anyone that we buy things from that they don't want to honor. If they want to honor our complaint, if they want to make us feel good, fine. But if they don't want to honor it because we're touching at something that makes them a fair amount of money, even though they're fouling people up with it, oh, well then did you even know you signed an arbitration agreement? You want to get, I recently refused to buy Windows 10. You know, you buy something online, and the first thing you have to do, if you buy it from the computer digital software industry, the first thing you have to do is what they call click wrap. Right? Do you agree to all the terms and conditions? If you want to see the terms and conditions, you know, it's 27 pages. And frankly, even a lawyer would take a lot of time, maybe weeks, to understand what's in that document. But you click, oh yes, I agree. Well, I've been inured to that. I've realized that living in the modern world, I was sort of stuck with that. But then when I wanted to say, okay, you finally forced to buy Windows 10, they put a specific thing on the screen that said you agree to the arbitration provision. I refused. It got me anyway, by the way. Because a few weeks later, I left my computer on sleep. And there was Windows 10 when I came back with a note that said it would take a lot of time to undo this, and I was in a hurry. Windows 10. I am really angry with Microsoft, but there it is. But the point is, all of these agreements, and you sign them constantly, whether you realize it or not. I think you sign it if you go to the car dealer. And lots. The court has used a 1925 statute, which was never intended for this kind of arrangement, to revamp virtually all of our business rules so that the arbitration clause not only applies but it wipes out all sorts of state remedies, even though the 1925 statute preserved state remedies. No, the court says all these state remedies, they're inconsistent with arbitration. You can't do class actions in arbitration. A state statute that says an arbitration agreement is invalid if it excludes class action, that happens to be California law. No, that law is invalid as a violation of this 1925 statute. The court has also been shifting wealth to the wealthy and to the companies from workers. So I'm sure you all remember the Lilly Ledbetter case, where she had been denied her right to equal pay for equal work under the law for years. In most cases where you can't find out about something that's being done to you, the law gives you a certain amount of time after it would be reasonable to discover, or you did discover what happened, before you have to file a lawsuit. But for most of those years, Lily's opportunity to file a lawsuit ended before she could have found it, which was basically when a co-employee spilled beans to a beneficiary of this. And of course, in most of our offices, I don't know if this is true, because in state jobs, many of you know what each other is making, because your particular grade tells you what somebody is making. But most of us don't know what each other is making. I know only for a very few colleagues, because the school is required to file a 990, I think it's called, for people who are making a lot more than the rest of us. But most of us, I don't know. I've been working with somebody on a brief that I was talking to Mark about earlier. I don't know what he thinks, and I don't think he knows what I think. Doesn't really matter to me. I don't think it matters to Keith, but it mattered to the late. I'm blanking. There's my 75-year-old granddaughter, Kathy Katz. It mattered to Kathy, who was in fact denied equal pay for a long time. In that case, it was a dean of the law school who realized the injustice and straightened it out. And I don't know if he completely straightened it out. I don't know those details, but I know that it was a dean who saw it and said, this is wrong. I benefited from a dean like that when I came to the law school. I got a raise before I came. And I called up and said, I didn't sign up for that number. And he said, well, before I sat with structure and you walk over there. So, okay. Some deans are real nice and real good. I appreciate it. There's also a very famous case where home health care aides, someone who was poorly paid and hardworking people, denied their benefits under federal wages and hours. And the court said that was okay because they really didn't work for the patient, they worked for an agency. My dad had home health care aides. He died at just a few months shy of 100 years old. And for the last year or so of his life, he needed help. And for a while, he needed 24-hour help. Before even the agency said, we can't handle it, we had to put it in the nursing home. We used an agency. We were offered a solo individual to do this. And my wife and I realized that if she ran into problems, Papa was going to have a bigger problem. And that we wanted to work with an agency, but the poor folks that worked for that agency were not covered. That's an injustice that has actually been perpetrated since the New Deal. It was one of the many deals that took place in the original passage of the Wages and Hours Act, the Wagner Act, which, because it cut out, among other things, this is not exclusively what it cut out, but it cut out the two professions for which blacks were a large percentage of the workforce. People who came to our houses, our maids, and people who worked in the fields. And as you can see, there's a lot of kicking and screaming about rectifying those injustices many years later, because everybody has gotten used to, not everybody, the employers have gotten used to those rates. But the court interpreted an ambiguous provision in such a way that these people were not covered. Weakening labor unions. I don't believe I've ever been in a job in which I was covered by a labor union. But I have bargained against it. In the legal services program in New York, before I got to that shop, there had been a union election, and I was in the management when I got to that job, and so I was bargaining against the union. Bless their hearts, they all wanted a flat, this is a long time ago, this is 1970, probably 4. They wanted a flat $10,000 for everybody, no matter what the job, lawyer, secretary, janitor, whatever it was. While those of us in management really wanted to hold our lawyers, so we had a different view of what should happen. But and so I got a rather unusual exposure to the unions in that job, the way that they were. But the court has been taking away pieces of their funding. I haven't noticed them taking away pieces of the corporation's funding. Right? If I buy, this is an LLB, and I don't actually like the heir to LLB's politics, but when she goes to spend her earnings off my jacket and whatever else you and others buy from LLB, they're very good. I mean, they take care of their customers, no question about it. But when you buy something, they don't then turn around and say, can we use the profits we made off what we bought from you in order to spend it on these very conservative candidates that you might not like as customers? You don't get asked that question. But you do get asked that question when you, in effect, buy a union's services, bargaining on your behalf about the wages and hours, the wages that you're going to be paid, the hours that you're working, and so forth. So the union has been, the unions have been somewhat degraded by many factors, but that's been one of them. And that factor is in the one area of union organizing where they've been growing. I forget the name of the specific unions that, well, there are several in New York State. Unions that represent office workers, that represent state employees. Those unions have been growing nationally. And those are the unions most affected by what the court has been doing. Well, not the only union cases of significance, but they are some of the most significant. So in each one of those areas, those are all financial areas where money is involved in one way or another. And the court has been cutting back the responsibilities of the companies, corporations, and it's been loading the costs of company behavior onto the rest of us. Let me move to another area, the Bill of Rights. In the talk, Trudy, that you heard, I was starting. because there are some cases in the Bill of Rights area that have me furious. And I'm just going to describe them briefly. But basically, the court has confirmed the unreliability of the criminal process, leading both to injustice and, to many ways, to exclude people from participating in the political process locally and nationally. So there's no remedy for deliberate prosecutorial abuse. Abuse that has knowingly, that is, the prosecutor has been well aware of the damage the prosecutor was doing, kept innocent people in prison for decades. I guess I will stop a little bit and talk about men. A man by the name of Goldstein, an engineer, was picked up, charged, convicted of a crime he did not commit. And he spent 25 years in prison for that charge, until finally he was released. Around the time that he was convicted, a Los Angeles County grand jury exposed the kind of practices that would lead to the kind of misleading evidence that the prosecutor brought in his case. What the evidence had to do with the misuse of jailhouse informants. If you create a pipeline and they know what's in that pipeline, they can manufacture stories. If you tell them what you need manufactured, they will manufacture it for you, and that's what the grand jury report said. And then on top of that, when you make sure that the records in your office make it impossible for whatever attorney is answering questions when they get fed in on the opposite side, from the opposite side, about were there any agreements between your office and the defendant in exchange for that person's testimony. The office can't say, because the lawyer has no place to go check. They've talked about creating a database, and they didn't create a database, and the documentary evidence in that case were they didn't because they realized, well, they might have to answer questions. By the way, in a case that even most lawyers can't find, unless they know the right lawyer to ask, the 10th Circuit, that's basically the mountains in the West, a panel, circuit courts of appeals, the federal courts of appeals, decide cases not with the full court sitting on most of the cases, but a panel, usually 3 judges. And a panel of the 10th Circuit decided that making deals like that was bribery. And they said prosecutors are not excluded from bribery laws. You can't do that. The full panel, the full 10th Circuit, all the judges of the 10th Circuit got a whiff of that, and they said, how are we going to convict anybody if you can't bribe people for the information? And they not only vacated the decision of the panel of the 10th Circuit, they withdrew it from the electronic media and from the indexes. So if you don't actually know where to find it in the paper copy, you can't find the Singleton case. It was United States versus Singleton. I'm sure there are many United States versus Singletons around the courts, but you can't find that case unless you literally know the page. But it is bribery. And if you can't even tell the jury so that they can consider what did the witness get for that testimony, they don't have a good way of deciding how reliable that testimony is. And here's a and the rules that have required. Am I moving around too much? For the screen? I just looked over there. It's like, the rules that have required prosecutors to turn over that evidence have existed for approximately half a century. No question about the fact that the rules were in force when the prosecutor decided to make it impossible to find out whether somebody had been bribed by a lawyer in his shop. But the court said, what's 25 years? You're a prosecutor. You deserve not to be bothered for any of your misdeeds. You and I, if we do the slight, if we scratch somebody's car, that's a tort. But a prosecutor, they don't even have to be careful. And just in case we thought that they were kidding, the follow-up, 1 or 2 years later, they did another case that made the same point. I happened to be sitting in front of the attorney who was going to argue the case, not from Los Angeles, but from the other LA, from Louisiana, actually from New Orleans. And he said to somebody within my hearing, he and I weren't chatting, but I was sitting directly in front of him, that he didn't think he had a winnable case because the behavior of his prosecutor was that bad. The court said that no one can touch a prosecutor. If this was a meeting of lawyers, I would have to describe that more carefully and say no one can touch a prosecutor in almost any case. And the ones that you could touch a prosecutor for have absolutely nothing to do with this kind of thing. In another case, all of this is in the last 10 years. The court said a defendant or prisoner who has been tried and convicted does not have a right to have somebody test the DNA evidence that was collected for his case. Whether or not anybody ever did test it, but it's there. It's lying around in some police locker. I want to test that DNA evidence. You're all probably aware that the Innocence Project, which is based at Cardozo Law School down in New York City, has affiliate relations with lots of state innocence projects now all over the country, has been based on DNA evidence because they could provide answers that were pretty black and white with that evidence, and make it pretty clear that somebody could not have been the person that they were trying to convict. Now that kind of evidence is only useful in certain kinds of cases, like rape, some murders, and so forth. Nevertheless, they've been quite successful with that. The court says you do not have a right to that evidence. And in case you didn't get the point, there's another group of cases in which the court has said that if you claim to the court that you are actually innocent of a crime, you're languishing in jail, you may be on death row. The original case that came up was not a Roberts Court case, it was a Renters Court case. It came up, was decided in 1993. My class looked at that case, and there was evidence from a retired Texas judge and from a person who had been a child at the time but was in the car when the person, his father, committed the murder. And both of those people signed affidavits, and my students, and I happen to know Herrera's attorney, one of them, came to the conclusion that he probably wasn't guilty of the murder. And so, you know, I have a spectrum of students. Some of them are very liberal, some of them are very conservative, and that was certainly true that year. Every one of them came to the conclusion that the court was going to provide some relief for Mr. Herrera. That was in the fall of 1992. In March of 1993, he was executed with the blessing of the Supreme Court, saying actual innocence is not does not create an obligation. The probability, Blackmun, Justice Blackmun, wrote in dissent that if it's probably the case that a person is innocent, then some court should hold a hearing to see if there's fire where the smoke is. Rehnquist specifically disavowed that. He came up with some fancy language about the extraordinary case, which was basically designed to keep Justice O'Connor, Senator O'Connor, who nevertheless wrote a concurrence saying it would be outrageous to her to execute an innocent person. But the decision was there is no such established right. Maybe in some future case we'd find a right, but there is no such established right. And there have been several instances where that case has come back to the court, including several instances on the Roberts Court. And the law, as stated by Justice Kennedy, I think he has written every one of those cases, is still that there is no right to a hearing on facts of that sort that make it seem like this person is very likely an innocent person, even though they may be going to the gas chamber or whatever means of execution the state has. So what that means to me is the court isn't particularly concerned about whether you did it or not. The way Rehnquist had stated it in the 90s was finality was the issue. We just can't constantly keep going back over old cases because somebody comes up with new evidence. That would be a waste of the court's time. So, putting it another way, the lives of innocent people isn't very valuable to the court. It's less valuable than the courts spending a little bit of extra time to make sure that this was the right decision. New York, by the way, does not follow that rule. I don't think it ever has. And many states, I don't actually have the count, but my understanding is that many states do not follow a rule anything like what the Supreme Court does or what Texas was doing, which is why the case came up, because Texas followed a rule that it's all over. Nobody has any ability to touch that case except possibly the governor. You can really see the governor signing a clemency petition in a murder case in Texas. What that means is process. I don't want to call it due process because it's not the process that we are due, but the process that we get remains a tool of control. It remains a tool of control locally, it remains a tool of control in states and nationally. And it's, if not those specific cases, it's that mindset about we have to control the people and it's just a clerical thing and we have to just keep moving along. That is part of what creates the new Jim Crow, where we have imprisoned a very large percentage of African Americans. And if you think about that, notice you're wearing a button. It's pretty obvious, I think I can say it was a Bruin button. We're not hiding it from any of us. It might be in the general election, if he had a chance in the general election, that those votes of the people in prison would have been votes you needed. I mean, it doesn't follow from saying, oh, that's some other group. Those are African Americans. Therefore, I don't care about their vote. actually, I want their vote for my politics. And I suspect most of you, given the name of the organization and the few of you that I do know, probably does want the vote of the African American population on many issues, although there are always things that we'll disagree with each other about. But the larger point is that unless we get control of the criminal process, it can and is used politically. In fact, right after the Civil War, there's a very famous massacre known as the Colfax Massacre. There were two fairly recent books that were written about that are stomach-turning, but well worth reading. And I think Colfax, C-O-L-F-A-X, is in the of both of them. But that largely changed the vote in Colfax County, Louisiana. That's why it was done. They shot. In those days, it was Republicans, people who supported the northern position of the Civil War, and the free blacks, who, of course, promptly became Republicans. So the use of we're seeing the use of the engines of the criminal law trying to be cranked up in this political campaign. We saw them cranked up against Bill Clinton not so many years ago. But it's pretty obvious that the criminal law can be a weapon in politics to change who's going to win elections. It can be because you take out a particular political leader, and it can be, if it's generalized the way the new Jim Crow does, that you take out a whole population and therefore change what the public is going to be voting for. So that's another large way in which the court's treatment of the criminal law is affecting American politics. Moving along to self-government, I put it self-government. Moving along to those things that are more obviously self-government and don't need me to draw the connections the way I did with the wealth cases and with the criminal cases. I mentioned some of that before, the defanging of the Voting Rights Act. I always thought Pamela Karlan, who's at Stanford, put it in the most succinct and beautiful way, because there was a very clear record of constant requests by the covered states to change their voting practices and rules in a variety of ways that a succession of attorney generals of both parties had disallowed because they had obvious racial impact. And she said, if the doctor gives you some medicine, and but the argument that some people were making was, hey, more African Americans voting in those states, those covered states, than they are in states that are not covered. And Pamela Karlan says, look, if the doctor gives you some medicine. I had some sort of sinus thing last summer, it lasted a long time. And so I was on some pretty strong courses of medicine, and they tell you, take this for 10 days. I felt better after eight days. I didn't stop. Turned out that they had to give me more later because it kept coming back until we found what was the cause. But her point was, we shouldn't stop taking the medicine as soon as we feel better, because the problem is still there. And you could see on the basis of all the requests that were coming into the attorneys general that the problem was still there. But as far as the Roberts Court was concerned, no, we've solved the problems, and every state should be equally able to screw up the votes of African Americans and other minorities. So that was one of the effective things that it did to basically to disenfranchise a portion of the population. And the right to vote, of course, very much affected in the cases dealing with voter identification, which the court said, well, that was okay, even though lots of poor folk don't have driver's licenses. I went in, do you remember when New York was offering a special license plate that would do, not license plate, driver's license, that would do things for you that your regular driver's license could not? And I had to get my license renewed in that period, and I said to the guy, well, how do I get, let me get one of those special driver's licenses. It turned out I couldn't find my Social Security card. I still can't. Now, okay, in my case, I've got a flexible schedule. I'm a law prof. I'm there for my classes. As long as I get my work done, I don't clock in on anything. I could get down to the Social Security Administration office and solve that problem. I still haven't been able to find it, by the way. If any of you have it, let me know. But my point is that if I was an hourly worker, that's a day's wages, or half day's wages. That's expensive. And if I don't have a car, we had a guy working for us, black guy. He's working for us, just doing some chores in the yard and stuff like that. And at one point, somebody did something to him that was somewhat outrageous. And we got a lawyer, and the lawyer won for him the judgment, which was the price of a car. And Jeff got a car, and all of a sudden he had a job. That was the problem in the first place. So, there are all sorts of problems that people have. How do you get to the office to get the paper? What does the piece of paper cost? I had to get a birth certificate for my long deceased sister. I just wanted to go visit her grave. I never met her. She died before I was born. But I've seen pictures of her. She was 3 years old when she died. In the 20s. It's not supposed to happen. But it certainly explained why my folks were frantic whenever I got a sniffle. It was the ear infection. Almost all of us had kids with ear infection. But I had to pay for that birth certificate. Now, I think it was $21. That was a few years ago, so maybe it's a few dollars more. Maybe even 25. But again, if I was a poor person and I had to get that document in order to get the driver's license that I needed, in order to have the picture identification, that's $21 plus the cost of transportation, plus the half a day I have to spend at the Social Security or whatever other office I need to go to get some other document. And God knows what other hoops they're going to make me jump through, and whether this is one visit to the office or 2 or 3, because, oh, I got this first thing that they told me about, and I come back and there's something else missing. It can get very expensive. So voter ID can keep a lot of people from being able to vote, especially if the state is not willing to lift a hand, because it could do the communication with the birth certificate bureaus in other states and check out that information. The state could do that for you if it wanted to. They just didn't want to. So that's another one of the cases. There's another case down well, it was fought over a judicial election in New York City by Judge Lopez Torres, who was a judge in the lower court. But have you ever noticed, thought about the fact that you walk into the voting booth and you'll see for a particular judgeship, they're endorsed by all the parties? Ever notice that? Did it ever bother you like it bothers me? you know, I look at some of those endorsements and I say, I don't want somebody who's endorsed by. And then all of a sudden, I don't have a choice. Because everybody endorses them. Well, it turns out that there are all sorts of political deals that the bosses of the political parties make with each other that result in those cross endorsements. But how do they get that power? This is all set up because New York State election law sets up the rules for what you have to do to get the endorsement of your party. And then if you don't get the endorsement of your party, what you have to do to challenge your party endorsement in the primary, or what you would have to do to get on the general election ballot. And the end result is that New York State has the bosses of the parties that power. And they say, well, the parties could have done it that way anyway. A proposition that I once wrote a brief in support of, that the parties could do things by having a party official being given the responsibility, but that the state can't do it for them. And we actually, in the 80s, we had the Byrd Report online with that. There's a whole bunch of cases that came out of the 1972 Democratic Convention and continued for about 20 years. And I and some others were involved in one of them in the mid-80s. And we established a rule, of party autonomy. Question period, if you want to know, I'll tell you about Justice Marshall's case, which was rather interesting. To the Roberts Court, that rule no longer exists. It's not only okay for the party membership to say, we want a party that selects its candidates in this way. And the membership isn't going to do that because we're all used to primaries. So we're not going to say, okay, the leaders can do it. The reason this case came up was a special situation in Connecticut where the supporters of Lowell Weicker wanted to invite in the independents. And so the issue was, can the party do that, or can Connecticut block them from doing it? That's the way it came up. But the Roberts Court said, no, we can set it up so that the bosses are in control. Scalia had told somebody that I know fairly long that he believed in a conception of political parties in which they would have a great deal of the power that has been taken away from them. Power over patronage that's been, to a certain extent, taken away from them, for example, and this kind of power over nominations and so forth. The point, I keep going to bring this, and the other side of this. Well, let me add one more. The gerrymandering. The gerrymandering rules are designed so that the politicians pick their voters, their constituents, instead of the constituents choosing the politicians. I could show you how to gerrymander. It isn't very hard. The court has not only said we have no decent way to control gerrymandering, which is, there are arguments that you can make. I don't think they're good ones. But it has actually said that protecting a political incumbent, singular or plural, is a valid purpose of election law. And it is so important that even if they think that election law or election districting has been done in a racially discriminatory way, it'll overcome that. So these are all steps where the court has been reducing the legislator's dependence on us. The gerrymandering, the protection of the party bosses, the ability to control who's in the electorate. And the other side of it is the court has been increasing the legislature's dependence on the few. Citizens United and a whole group of public financing cases has been that part of the equation. Less dependence on us by law, more dependence on the few by law. From the political science perspective, this cycle of increasing dependence on a smaller elite is part of what makes politics go awry. It is part of this dictator's game, or the vicious cycle that ends up in a dictator. Because the important group, the people that can make or break elections, become fewer and fewer. The goodies that have to be shoveled in their direction become more and more. The rest of us count less and less. And the process feeds on itself to a point where, from the political science perspective, from their research on how democracies have been lost, democracy is at risk. So, in every one of these cases, there are always two messages, I think. One is just a question of justice. What happened to poor Goldstein in LA? What happened to all the people who've been involved in the mass incarceration that Michelle Alexander calls the new Jim Crow? Bless her for doing that. It's not a story that we lawyers didn't know. It was a story that she caught the public's imagination with. And thank heavens that she did. Maybe we can get something done. In all of these ways, the politics is being taken out of the people's hands and put into fewer and fewer hands. And that then creates a situation in which there's too much at stake. There's too much at stake for the people who've got everything. And there's less and less at stake for the rest of us, which means we have less and less stake in the system if it doesn't protect us. That's dangerous. And that's really why I wrote the book. There are more areas that I could talk with you about, but just looking at the plot, I'm thinking I've had a little bit of too much of a run on the mouth. But thank you for listening. I'll be happy to take questions.
I'm sorry I was in and out because we're fighting a fossil fuel project. I wanted to make sure we had a sign up, so I apologized. I got the beginning and the end.
Oh, I gave you 5 demerits for that walk.
Yeah, okay. But I've always been part of the Action Faction, and I remember 1982 because we all got arrested doing a war chest tour during the Democratic National Convention because we maintained that both parties.
I've always been embarrassed by the fact that I was never arrested in the Civil War.
Oh, we can change it. We can change that. No problem. All right? I have a thing you can come to. It's good. But what happened was we maintained that both the Democratic and Republican convention were both run by the same people. And we proved it because the Democratic convention cops beat us up worse than the Republican convention cops. We can prove this. And that was San Francisco that year under Feinstein.
Well, you could have gone back to Mayor Daley to prove that.
Well, Texas wasn't that great either under the Republican. But anyway, so that was 1982. But, you know, I just want to say that this is going to be a very interesting Democratic convention in Philly. And I do think that we got to look at Sanders because I think you're seeing a groundswell of Democratic sentiment like I have never seen in my entire life, that people care and they're pissed. And since I've been, you know, in college, you know, and studying, I was at a history degree there, the concentration of wealth and power has gone from here to here and only worse. You can't even describe it anymore. It's a pivot, it's, you know, like a spire, you know. And I mean, it goes straight up. And it's worse internationally than it's ever been. And it's worse nationally, worse than international by far. and we're like this, and it's gotta crumble. And that, you know, we were saying that in the 80s, but now it didn't change, it got worse. And you know, I guess I'm wondering what you think about the effect of like these tens of thousands of people are coming out for Sanders. He may not get the nomination. Depends on superdelegates, I imagine, which is like obscene. But what do you think this is going to go? Because I can't see how, if we get Clinton in there, and I'm not even talking about other options. Let's say Clinton's in there. I can't see that these tens of thousands of people who've been coming out, all in states that are never active, are going to disappear. I think they're going to be here. What do you think is going to happen?
I hope so. I mean, Sanders is, the basic message that Sanders has been giving us is absolutely right. And it's a message, of course, that we got from Ralph Nader.
Right.
And it's very much like the message that we will be getting from Elizabeth Warren. It's not a message that's unique to him, but as with Michelle Alexander, he's the one that caught fire.
He reminds me of Howard Zinn.
And that's a very good comparison. You know, my political, I really didn't come here to talk about Sanders versus Clinton. Some of my political vision was shaped by 1972, because I think a lot of us saw, I'm blanking again, McGovern, very much the way a lot of people are seeing Sanders today. And McGovern got praised. And so I just started to say to myself, you've got to remember that you've got to keep pushing the American people, but the American people is not going to be where I stand. They just aren't. And so I've got to live with that. So I did a commentary on WAMC. I don't remember what month it was, but it was probably early in the last year. It was the beginning of the campaign period. And it was basically Go Sanders to push Hillary left. That's what I wanted Bernie to do, because I saw and I appreciated the accuracy of his message. I've never thought he could end up in the White House. I'm delighted by some of the things that I've seen. Maybe I've been proven wrong. Nobody's been proven anything, because that vote hasn't happened. And one of the little factoids that found its way across my desk from somebody whose blog I admire and subscribe to, who teaches at the University of Michigan, is a Middle East expert, sent around the information that the Iranian-American community was for Bernie. Yeah. And for those of us who are Jewish, at least by birth, if not by avid practice, that's a very interesting fact. I never felt any problem being Jewish when I was in Iran, and I went to High Holy Day services there. But things have also changed since I left. But it was interesting information. So yes, I think he has opened up a lot in America. But I can think back further, because I can remember the campaigns of Adlai Stevenson. And what I remember about the Stevenson campaign is it got lots of us into politics. And he lost, but we didn't drop out. And Kennedy was killed, but we didn't drop out. I think what really hurt us in many ways was the Vietnam War. I don't know what Kennedy would have done. I hear historians talking opposite sides on that one. I think Johnson made a huge mistake on Vietnam. I understand the politics, but for me, war is a political decision. People's lives are at stake. So I think that was a horrible decision, and it split my party, probably some of yours, very, very deeply. But that still didn't mean that McGovern was going to put it all together. And it didn't mean that when Nader ran, saying exactly what I believe,
Yeah, Nate's good.
I wasn't going to vote for him.
He's a good man.
Because, not because I had something against him, but because I knew he wasn't going to win. That goes even, I mean, maybe this is just built in. My father taught me how to play the piano, right? And my father wanted to vote for Wallace in 1948. I was a little kid, but I remember that election. And I remember him say, I didn't listen to the political arguments, but I listened to the conversation in the house, around the dinner table, or with friends. And I remember him saying he thought Wallace was the better man, but had no chance, and he wasn't going to waste his vote.
You know, one...
Wait a minute, we've got another question over here.
Sure. Let me explain.
Are you familiar with, I think it's Sheldon Wallen, who's written and invented totalitarianism, and his theory is inverted totalitarianism. I think he's passed away. He was a professor at Princeton and a number of
Well, if he was at Princeton, he must have been.
And basically, what he describes...
Because that's where I went, right? So I had to be good.
What he describes is that that's what we've been following. We're not a traditional totalitarian government, but inverted basically that we have a deep state somewhere that makes all the decisions and the rules and has the power and control. So the question is, are we a democracy? So I'm just curious, and if you haven't read him, I suggest you do, but do you have what are some of your thoughts on how you would describe the current situation?
I thought a lot about the description of democracy. And there are a lot of descriptions in the political science literature about what democracy is. I've almost quoted somebody who would have been an instance of what you're talking about, because Schumpeter wrote a book, Capitalism, Socialism, and Democracy, and he said, and I can't quote him accurately, but he said something like, if communism comes to the United States, it will come dressed in red, white, and blue. But he argued that all you needed was sort of two large entities and the people get to choose between them. So he would have been a proponent of what you said. On the other hand, there's a lot of historical scholarship that define democracy in terms of the most inclusive decision-making ability, and as well as the most competitive. Robert Dahl, whom I met but never studied with when I was in law school, described democracy as defined both by the inclusion of the population and the competitiveness of the process. What Dahl's idea creates is a continuum from more to less. And there is a particular Finnish political scientist by the name of Tuomas Vanhanen, whose son has been a prime minister of Finland. And Vanhanen actually tried to draw that whole arc of possibility from the most democratic countries, and we're not there, to the least democratic countries that you could still call democratic. Although some people extend his stuff even into the autocratic countries to identify the power relations even there. What I tried to do was to say, wherever we are on that arc, we don't want to get worse. And more than that, because I felt that I had to be talking across the aisle, that I didn't want to assume my conclusion by saying I want to be out here. So what I'm saying is, if we're too close, we can easily go over to the other end. I understand what you're saying, but there are a lot of distinctions to be made in the way many of those folks operate and the power that they're given and the ability of politics is a strategic game. I can make a brilliant chess move and somebody can beat me because they have the answer, or my brilliant chess move was made in the wrong game. Actually, I can't make a brilliant chess move. I like to tell people I once beat somebody who once beat Bobby Fischer, but I'm not telling you anything about how old anybody was or how rusty anybody was, etc. I can't make a brilliant chess move, but I know that even people at the very top of the chess game can make a brilliant move in the wrong game, and that happens frequently. And you don't know. You don't know whether, when you're starting out in a campaign, can you take Bernie over the top? My point is, in politics, you have to be, it's like, I want to do another analogy here, because they always used to talk about when you're playing sports, you always have to think of follow-through. You always have to think of the next move, whether you hit the ball in the air or you hit it on the ground or whatever. You always have to be thinking about what's the next move. I used to like to pitch. I used to think, oh, when I release that ball, my job is done. Except sometimes it came back at me, and I may or may not have been in a position to catch it. And so my point is, politics is never over. And we do things without knowing how they're going to turn out. But it's necessary to keep yourselves in position so that you take advantage of what you've put together. Let me give you an example that's more to home. One of my former students is Colin Donnarumma, that I suspect some of you know, because he was one of the people who was very instrumental in the Occupy movement here in Albany. He's a wonderful guy, a brilliant guy. You could say that Occupy was unsuccessful, except Occupy was Bernie's opportunity. Occupy changed the political discussion so that what Elizabeth Warren is saying has an audience now. Occupy did move America, even though it, quote, lost. And you could talk a lot about brilliant and very important losers in history, because they got out there and they pushed the politics. And one of the things that's happened throughout American history is that parties have lost because the major parties took up their ideas. So did the Populist Party lose, or did it win because their ideas were adopted by the two major parties? And so I don't, you can regard me as being too limited in my objectives if you want, but I don't see this as about whether a particular candidate wins. I see this as about whether American politics gets pushed. And in the case of the court, I've been saying the Republicans cannot bring, what's his name, the candidate. For the Supreme Court. Obama's nominee, Garland. They cannot take him up. And the reason they cannot take him up is because so many of the rules that determine whether they individually, never mind the presidential candidate, whether the congressman will come back to Washington, are involved in what the Supreme Court has been doing. They can't have a Supreme Court that would change those rules about gerrymandering. And gerrymandering was 5-4. It came very close. They can have a Supreme Court that will change the rules about voter ID or the Voting Rights Act. That if we have any chance to go where Alice and I and you want us to go, we have to have a court that will preserve that chance for us, and we have to preserve the movement that will enable us to rush. If you're playing football and you get stopped before the 4th down, you don't say game over. You think about field position and you try to maintain it while they've got the ball. I mean, that's the way we have to think about politics. It's given what's going on now, how can we push the game forward in our favor? Mike?
I'd like you to speculate a little bit. What would...
That's all I do.
What would... It's a double-barrel question. What would possess...
As long as you're not on the trip.
What would possess a good old boy like Roberts to uphold Obamacare? And the other question is, what would possess an aspiring liberal president to push the Pacific Partnership as portrayed in the TTIP material? What is the mentality? Why would Roberts abandon his Republican friends?
Completely different questions, Michael. I don't know if you realize how different they are. With respect to Roberts, it is speculation. I've never met him. I've seen him. I've been to the court. I've seen him, but I've never spoken to him. And you know, his ideological colors were flowing in a part of the Obamacare case, but the tax case was a harder case for somebody like him. There were reasons why the Solicitor General was urging inside the administration to urge the tax argument. They saw it as a stronger one that was less politicized. I think also it's possible that Roberts was reading the political tea leaves. And, you know, my thoughts about that case were always that it was, we were going to win or lose depending on when they decided it. Because if they decided it before the election, it would be for us. If they decided it after the election, it would not be. Because if we were looking at the political tea leaves, a decision the other way would have gotten us out to the polls and kept their supporters indoors. So I don't know if he thought that. The likelihood that some of them thought that, I think, is strong, although the others didn't vote the same way. Maybe Roberts was the only one. You know, and there's also this big ball and small ball. I don't know what was in his private circle of people that he relies on. There's so many factors. When you switch to the question of the Pacific Trade Partnership, wow. Because you're thinking about the domestic politics. And Obama is actually thinking of a much different problem, which is how long are we going to be mired in the Middle East in wars that we can't deal with, that we're only making worse? And can we settle things down in the Middle East through the pact with Iran, and then turn to what is likely going to be a huge problem in Southeast Asia? China, after all, is the most populous, and one can argue that if it's not the most powerful country on earth now, it may only because they haven't flexed their muscles yet. And Obama is thinking of that problem. Now, how do you weigh foreign policy against domestic policy? Difficult question, but I'm very torn on that, and I'm not even terribly happy that Hillary has gone where she did, because I would like to provide all the benefits that you and I want to provide through a different decision on that pact. But I'd like to provide them in other ways. I mean, I read Krugman, I'm sure you do too. There are lots of ways to deal with the strength of the American economy and the way that it rewards its workers, including some of what I've been talking about, other than by preventing a pact which would expand American trade with a part of the world that's likely to be very contentious over the next 50 years if we should live there. So, you know, in Obama's case, I see a completely different issue. I have enormous respect for that man. I have been learning one thing. If I've never learned it before, I've been learning it recently, and that is, thank God I'm not president. That job is way above my pay grade. Yes, sir.
Well, given
The answer is no.
given your
Absolutely
qualification
not.
for that pay grade, and your background, that you're from Stanford, and you have a lot of people.
I'm
who
not
are-
from Stanford.
You know, you weren't. You didn't go there. I thought you did.
No, I went to Princeton.
Princeton.
Princeton and Yale.
Oh, that's-
So I figured
those
that
are-
disqualifies
those are pretty good,
me
too.
from active politics.
But with all of that, how the hell can't you guys come up with a solution to this situation?
Which situation?
Oh, well, the Roberts Court and the executing innocent people, and, you know, so what do I tell my 20-year-old son that there's hope in this situation? Because what I'm hearing is we need the Bernie Sanders rabble to keep their spirits up and keep pushing and not turn to pitchforks.
Have any of you ever listened to a folk singer by the name of Peggy Lynn? Who?
Peggy who?
Peggy Lynn. Oh, you missed something. She now sings with her husband and one other person, and they sing as the Jam Crackers, which is a reference to the logs that used to be sent down the river from the forest to
Jam crackers, okay.
But she's been called the First Lady of the Adirondacks with some of the songs that she's done. And she wrote a song about Mrs. John Brown. And I remember going up to her after she sang it. My wife had met her some years before, and so I just went up to her and I said, Peggy, I don't know how you are able to sing that song without breaking down. The chorus, I can't sing it. I can't do that. My dad was a musician. Went to the Juilliard School. My daughter teaches at a conservatory, and I can't carry a tune. If any of you ever know who Milton Babbitt was, he died recently, but he literally gave the class a little mini lecture about why Gottlieb couldn't sing. And I love him in spite of it. He was wonderful. So I will not sing it to you, but the chorus was, we may not see the slaves go free, but neither did Moses see the promised land. And of course, the slaves went free a few years after that song. It portrays itself as having been. Of course, they didn't go free and go to heaven. That's not the way it worked. They went free and went into a century of struggle that isn't over yet. A century and a half of struggle that isn't over yet. But things do get better. At least some of the descendants of slaves are doing quite well. Met some of them. One of them is perhaps Albany Law's most famous graduate, Richard Parsons. who was the CEO of AOL Time Warner. I guess he's less famous now than Megyn Kelly. But things do get better, and that's why if we're not in it for the long run, we will lose. If we're in it for the long run, we can pull victory out of the jaws of defeat.
Some of us, when we look at history, don't view things as getting better. We see the unions being destroyed, we see the new Jim Crow, we see less democracy, we see more spying on us, we see more wars. And I think one of the lessons of what we've seen so far in this election period, where we will have two people running against each other. One has the highest negative rating of any presidential candidate ever, and the other one has the second highest negative rating of any president. And what we've seen was both from the left and the right, people saying that this two-party system, this incremental thing, doesn't work anymore for us, especially these youth who don't see things, don't see a bright future in terms of things getting better. So, and when you say something like, well...
but it's the revolt from the right that's really scary.
It is, but that's not ahistorical. What happens is when there are problems, people either look for political solutions and move to the left, and if those solutions are not there, then they move towards scapegoat and move to the right. And we're seeing that same phenomenon in Europe.
And that's partly what I'm afraid of. Bernie is a symptom of what scares me and scares the political science world. He's not the creator of it, but he's a symptom of it. And that requires a sense of, and I agree with you, things aren't, it's not as clear as saying that things are getting better. Some things are getting better, other things are not. But whatever will not be tomorrow.
Well,
It just will
sometimes
take
things
longer.
do change quickly. I mean, we saw, for instance, in Egypt, where Mubarak was in power for 30 years, and 18 days later, he was gone. Now, of course, things have gone back there, but sometimes things reach a certain plateau,
That's
and then
what
they change
happens
quickly.
when the control is in the hands of people with weapons. And think about how much we owe to the American military for not having done that since the Civil War.
We've done what?
Not having tried to take over politics in the United States. They have their political views, and I agree with them. I disagree with all of them.
Overthrown.
Yes, yes, they do
changes
that.
Country after country after country.
That's right, but they haven't done it in this country. We owe a great deal to our military and our civil military tradition that has not happened. But they have their breaking points too, and one breaking point was the point we crossed in 1861. That was a breaking point. And the military, a large portion of the military turned treasonous.
Say more about that, would you? Explain a little more about that.
Well, Robert E. Lee and all the other officers of the Confederate Army had taken an oath to support the Union. They were commissioned officers in the American military forces. They put down their commissions and their medals and whatever else they had that showed that they were members of our armed forces, and they made war on those armed forces. That was an act of treason. And by the way, there's a big piece of the whole paragraph. These days when we think about the 14th Amendment, people are not remembering what all those paragraphs were about. But there's an entire paragraph of the 14th Amendment that's aimed at the treason of those people. And a large part of the impeachment of President Andrew Johnson was because he wanted to give them all their political rights back. And, you know, the Republicans, bless their hearts in those days, tried their best to stop Johnson from doing that. Another one of the paragraphs in the 14th Amendment was to prevent people in the North from having to pay for the Southern debt. So, sadly, you know, the first paragraph is all about what our rights and freedoms are going to be, and there's wonderful language in those provisions, often language that has been obscured because a lot of people, particularly Southern sympathizers, worked for a century to obscure the meaning of a lot of that language. But there's a lot in there that was designed to say this was a treasonous event and it must never happen again. Yes?
You know, one thing that I think...
I don't know that yet.
I'm sorry. One thing that I think that maybe we haven't thought enough about is that things have utterly changed with the advent of social media. And it is an opportunity for surveillance like we have never seen before. However, even surveillance has not stopped it from being a democratic force. And Sanders, I believe, is due to social media. He was almost entirely social media. And it worked because we have so many people who take their views from social media now. And it's not yet managed entirely by the editorial board of the New York Times.
I'm less yet, and I'm less worried about the editorial board of the New York Times than some of the other people that would be trying to get control of the social media. I was at a meeting, I guess it's a couple of weeks ago now, with a number of people, but one of the people in the group that I was supposed to be a facilitator for was Larry Lessig at Harvard.
Which who?
Larry Lessig, who wrote most recently, or relatively recently, a book called The Public Lost, which I think you will like very much. But I was asking him, because he, in an earlier part of his career, wrote a great deal about the internet, what the likelihood is of it remaining a democratic force. Because I used to teach mass communications law, which is different. I mean, I was teaching broadcasting law, right? But it seemed obvious to me that every attempt would be made by commercial forces to take the internet over. I mean, I've been using the internet since it was, you know, it was just in the universities, and it wasn't like this at all.
Right.
And I liked it much better that way. But I knew that commercialization was going to be there, and the government no longer owns the trunk lines. I was surprised when I learned that. You know, there's been a lot of joke about who created the internet and so forth, but the internet was a DARPA project. Defense Advanced Research, I forget the full answer. But it was a Defense Department project, and government owned the trunk lines that connected the universities. And it was actually originally created because if a bomb disrupted a telephone conversation, the conversation was gone.
Right.
But on the internet, there are multiple paths. The conversation just gets restructured. That's less true of it now because it's been privatized, because we've gone through a generation where we, the public, haven't been looking, and I've been looking and didn't know all of what was going on, maybe because I wasn't looking hard enough. But it's been privatized, and people now describe it to me as a loop. Not the fractious all over the place internet that it used to be, but a loop. Loops can be broken, literally broken. It's much less secure than when it was originally created to be a secure alternative to Ma Bell. And there are other ways in which I mean, we had the whole debate over net neutrality, but there are ways in which the commercial forces will try to gain net neutrality for themselves. And part of that's going to come to the Supreme Court, no question about it. So in politics, nothing is except for the moment. Everything is always changing. The internet is changing, the parties are changing, the opportunities are changing, and the thing that will keep them somewhat in the direction that we want is we have to stay out. I wish I could give you an easier prescription than that, although frankly it's Thomas Jefferson's prescription. And there are a lot of things that Jefferson said that I deeply disagreed with, but he was right about that. I mean, he did hold slaves. Very interesting to read Jefferson on slavery, particularly when he described to somebody in Europe that if you live on the latitudes of the Potomac, you're a hypocrite about slavery. If you live north of that, which means Pennsylvania and northward, then you believe slavery has to end, that we must end it. If you live south of the Potomac, which means south of Virginia, then you think slavery is forever and God-given. But if you live in the latitude of the Potomac, you don't know what to do with it. You depend on it. It's your income. It's your property. You don't really respect it. Washington freed the slaves at his death, previously saying, I will never own another. Madison condemned it while holding slaves. But in saying that we will have to keep fighting for liberty, Jefferson's right. I wish I knew a better answer. And so therefore, I repeat this message. Vote.
For who?
Well, don't vote for
The
Trump.
only two people you got is Attila the Hun or Genghis Khan.
Oh, I don't agree with that.
You
That's way over.